On the issue of discrimination, which was raised 2 weeks ago, I know we were told that when I proposed this conceptually 2 weeks ago, it would not be allowed under federal law because we have to treat all wired, telecom, and cable and wireless industry the same. In fact, that's not true. I will refer you to the 3-page memo from Mark Del Bianco, who is a U.S. Department of Justice attorney for many years, and then an industry attorney with Skadden Arps and many industry clients for years, who makes clear in the memo why what the federal law requires is you cannot pick winners within and discriminate among wired providers. You cannot treat wireless providers differently than each other, but you can treat wired and wireless industry differently under federal law because they are functionally different industries. And the verification for Mr. Del Bianco's memo, I asked that question to the top counsel for the utility subcommittee of the House Economic Matters Committee yesterday, and he agreed that was right. He says you're a home rule county. You have broad authority under state code in the land use article and the local government article. And you can do anything you want on utility poles as long as you don't run afoul of state or county law. State law doesn't regulate utility poles at all in the right-of-way. And the proof that the state obviously isn't running afoul of federal law is the fact that they treat wired and wireless industries completely differently. They have a vigorous regulation system for wired utilities, both telecom and cable, and they have no regulation of wireless utilities. The state is not afoul of federal law, and we would not be afoul of federal law if we treat them differently. And third, I spoke to staff at the PSC, who I was referred to by the House Economic Matters Committee. They said exactly the same thing. And they said, as a matter of context, that they have been dealing with these questions from local government officials and staff all year, and that industry lobbyists, advocates, as is their job, have been going to local governments all over the state and waving around the FCC order and saying, see, this says in this very esoteric area of law that most people don't understand that you just have to comply with what we want, and you have to allow antennas wherever we want them. And the expert at the PSC says he's been rebutting those claims all year from local government staff. Thank you.
All right, Mr. Hucker. Oh, Jeff, please.
Just a couple of things. Number one, as a matter of policy, it depends whether the council does want to be more welcoming than not. To make this a conditional use puts burdens on the applicants, burdens on the residents, burdens on staff. So it depends what process you want. And within the process of conditional use, by its very nature, it's deemed to be compatible within the zone to start with. The only reason you would deny a conditional use if it's at a particular location, it had particular adverse effects. Now, traditionally, that has been something like more traffic at one location, safety concerns for turning movements, some other land use that it's inhibiting. This would be very unusual for the hearing examiner on the basis of compatibility to say that a utility pole, which lines the streets, but is 10 foot taller at one location, is incompatible with the rest of the neighborhood. That seems like an odd determination to make. If this is not to be a prohibit service, then the vast majority, like 90%, you're going to have to, we're going to have to approve as a county, because otherwise there will not be the penetration into a neighborhood that is needed to enhance this service. So that's a little bit both policy and operational. There is one thing in the FCC order that speaks to general infrastructure, not just wired or wireless. It generally says that if for the purpose of something like aesthetics, you don't have the same controls on other infrastructure, then it's inappropriate to have on wireless communication. Now, I am not the expert that Mr. Hucker consulted. In the words of Tony the Tiger, the FCC ruling gives me great pause. But I know, terrible.
Just got that, yeah.
But the one other thing in there is the 40-foot setback. And at 40 feet, it may work. That we have 75,000 poles and light structures in the county. At 40, the difference between a 40-foot setback and a 30-foot setback is about 10,500 poles or something like that. It depends how they're distributed. If in fact there's an entire neighborhood that has that doesn't allow a 40-foot setback, that too may be a denial of service.
Okay, that's helpful.
Can I ask a question to follow up? I guess, Mr. Zients, I would point out I understand what you're saying about the hearing examiner. The hearing examiner would be allowed to consider the criteria that the council allows under county policy within our authority. So, that's one thing now, and it could change in the future. Where is the 90% figure come from?
I mean, that's a rough guess.
Is that a guess?
In my,
I thought so.
Wagner method.
You have to approve the applications or you're denying service, Mr. Hucker.
Right. The question is how many and in what places?
Again,
Actually, the question may not be that, because there's a shot clock and there are tremendous federal supports behind the applications.
Can I speak to the law?
Yes, please.
Okay. We're not talking about the FCC orders now. Now we're talking about federal law, which is removal of barriers to entry, which I just pinched it and lost it. And it has to do with the fact that you can't prohibit you can't have the effect of prohibiting service. And that's completely different than what Mr. Hucker is talking about.
I think we all agree, there's no one disputes that we are not allowed to deny service.
47 U.S. Code, Section 253,
So-
removals of barriers to entry.
Understood.
It's different
we
than
all
the
agree with that.
FCC order.
Understood. The question is what the courts will find. And at least two courts have recognized, if you refer to Mr. Del Bianco's memo, two recent court decisions have recognized that a locality does not violate Section 253A by enacting procedural requirements for wireless facilities, including small cell, that are different from or stricter than those that apply to companies providing other services. That's exactly what the PSC told me yesterday, that they view the federal requirements as a floor, and a locality can build stronger procedural requirements or setback requirements on
Right.
top of the
Which
federal
we would
requirements.
rely upon for the ZTA as introduced.
Right.
Yes, if I could to speak to that point. One is, we do impose additional requirements on wireless deployments through both the telecom, the tower committee, the transmission facilities coordinating group, and the submission of additional information, and we impose additional conditions regarding setback and height restrictions. To the memo that Councilmember Hucker is speaking to, I think it adopts a rosier picture of the law, and in the FCC order, they went out of their way repeatedly to pick the couple circuits that ruled in their favor and to say that we are specifically overturning the circuits that didn't rule in our favor. So whether or not that particular case will stand up, it's in a different circuit than we are. I will tell you that as part of our appeal of the FCC order, there were appeals filed in the Ninth Circuit within the 10-day window for the lottery in order to take advantage of that. But I cannot say that those are going to stand up. And frankly, we have challenged the FCC on two different occasions, specifically on the wireless, and in both times we've lost those cases, and I think we had, frankly, a pretty reasonable argument. So you can't predict what's going to happen on some of these cases, but
Understood.
but the argument that is going to be made is going to say that we have a need to provide service. And we have a need to deploy a lot more poles than we have today. And the reason we set the ZTA up in a two-tiered system between the taller and the smaller ones is that it allowed us to efficiently move through ones that would have the least impact and to reserve and be able to defend our ability to have the conditional use for the ones that have the most impact.
Okay, Mr. Berliner, or, sorry, you're done, yeah. On this item.
Thank you. I have great sympathy for this amendment. Had conversations, Mr. Zions was present, with our county attorneys with respect to this, and raised this issue long before Mr. Hucker put forward the amendment as to whether or not we needed limited use and conditional use, or whether we could have everything be conditional use. And I was told in that meeting with our county attorneys in no uncertain terms that that would be unlawful. Okay? If there is a different view now, Mr. Hucker has shared with us a legal opinion that says the opposite. What I need to understand is, why does conditional use in and of itself make it unlawful? I get that it's a burden. I get that. I'm sorry, the industry can contribute to the cost with respect to this. If we need to staff up, we can staff up with respect to this. We have a shot clock, we'd have to meet the shot clock. No question about that.
And the process, streamline the process.
And our community that I represent, Mr. Hucker alluded to, Bethesda, Chevy Chase, those communities, I hear from my peeps. They are saying, I want the same protections as a matter of due process. Not necessarily because it will change the outcome. Mr. Zions has suggested that we're going to have to improve 90%. That may or may not be the case. But then citizens have rights. So I need to understand why giving citizens rights in a context in which we must meet the shot clock is preempted by federal law. Because if this is a matter of policy, we're in a whole different conversation. If this is a matter of law, as someone who is proud of my practice of the law, I'm in a different place. So I need to understand exactly why conditional use in and of itself, where we hire more administrative law judges, where we honor the 120 shot clock, where we do what we have to do in order to process these applications in a time frame that is appropriate, why is that preempted as a matter of law? And I have to say, Ms. Nurmi, on several occasions now, you've been here before us, and we haven't had the county attorney here. I don't understand how we can be having these conversations without the county attorney here. We have Mr. Zions, whose opinion I respect and who I want to hear on this question. But I would ask you to get Mr. Hanson and Mr. Royalty over here. Mr. Zions?
A complicated question.
Actually, not so much.
Not so much. I think on it.
That was the
Hello,
fastest.
Joy, you did a great job.
Thank you. I'll defer to Cliff.
Okay. You get it on response time. We'll see on responsiveness. Mr. Zions, why is it, as a matter of law, conditional use preempted? Meeting the shot clock.
Right. Depending upon the interpretation of the federal order, under current law, I don't know that it is preempted, so provided the results of it do not preempt service.
Right.
And that will always be the test, as opposed to the test that we generally use with conditional use, which is it more adverse here than there? And it's only under a conditional use where it's more particularly adverse that you can deny. Now, if that denial, again, will result in the need for approval somewhere else in that area, if it's because of the coverage conditions that antennas meets. But as an absolute, if you meet the shot clock, if the results are not a denial of service, if your fees are reasonable, not in terms of what the real costs are, but reasonable in terms of the FCC saying that $270 an application is a reasonable fee, whereas our $100 for a fee, whereas our fees for conditional use right now are $16,000 per pole. If you change your fees, if you expand your service, if you're able to meet the shot clock and the result doesn't preempt service or prevent service, you could do it.
So from my perspective, this is about process. This is not about the result. The result has to be what the result is. But it is, the question that has been posed by this is whether or not all of our citizens should be given the same rights with respect to due process. Mr. Royalty.